3, 4. Can you hear us inside of the hearing space? HVAC technical support.
Can hear you on the WebEx. If you can hear on the room, then we're all good to go here.
Awesome. Stenographer, are you ready to begin as well? Okay. Ready to begin? Okay. Please provide a 5-second countdown.
5, 4, 3, 2, 1. Okay. Well, good afternoon and welcome everyone. I call this oversight hearing to order. Without objection, the chair is authorized to declare a recess at any time. We have members participating remotely today. Before I proceed, I'd like to go over some items for our members participating remotely. First, if you experience connectivity issues, please make sure that you or your staff contact our designated technical support so it can be resolved immediately. Members participating remotely must make a reasonable effort to participate on camera. It is committee policy that members will remain muted when not recognized, just like turning your microphone on and off during a hearing in person. This is out of courtesy to all members on this committee and so that background noise and interference do not interfere with another member who is recognized to speak. When you are recognized, you will need to unmute your microphone. If you wish to be recognized, please raise your hand and communicate through staff that you wish to be recognized and unmute your microphone and ask to be recognized. If you wish to have a document inserted into the record, please ask for unanimous consent and have your staff email the document to rashida.hassan@mail.house.gov. It will be uploaded to the committee document repository. Please keep in mind that you will need to refresh the repository page as it does not automatically update. If you need to briefly step away during the hearing, please keep your camera on and do not log off WebEx. If you need to step away for an extended period of time or participate in another committee's hearing, please log off and log back in when you're ready to resume participating. Please communicate this ahead of time to committee staff. Without objection, members will be recognized in order of seniority for questioning witnesses. This makes it easier for me to make sure all members participating have an opportunity to be recognized. Does any member have a question about the conduct of this hearing with members participating remotely? I now recognize myself for an opening statement. I would like to start today's hearing by recognizing the loss of Army Specialist Vanessa Guillen. Her death is a clear signal that something needs to change so that service women and men can safely report sexual harassment and assault. This committee owes Ms. Guillen and her family a debt of gratitude for her service. But more than gratitude, we owe her justice, progress, and improvement so that her death is not in vain. Please join me in a moment in silence for Vanessa. Thank you. Today we begin our discussion of the character of discharge determination process at the Department of Veterans Affairs and how veterans with less than honorable discharges can access needed benefits and health care at VA. We will examine how VA's outdated regulations and internal policies work to deny benefits to many eligible veterans covered under the law. Unfortunately, many of those veterans who are most at risk for homelessness and suicide because of mental health conditions like PTSD and MST. VA's regulations and policies need reform to make sure any veteran with less than honorable discharge receives a fair consideration at the VA. For Congress to propose solutions to these problems, we need to understand who is wrongly turned away by the VA and the impacts of those erroneous denials. In the wake of World War II, Congress recognized that even if a service member should no longer be serving in the military, it did not mean they should be excluded from help transitioning back to civilian life or treatment for service-related disabilities. That is why Congress allowed eligibility for VA benefits for veterans who separated under conditions other than dishonorable. Unfortunately, today we see that many veterans assume that without an honorable discharge, they are not eligible for any VA benefits. This leaves hundreds of thousands of veterans without services that can help them adjust and heal. Recent legislation allows VA to provide more veterans with health care and emergency care through VA's own humanitarian care directive. I applaud VA for working with Congress to expand its access to care as 22 veterans die each day by suicide. But there's still work to be done to provide timely access to care and benefits for veterans, especially during this time of unprecedented crisis. We know that some 500,000 veterans with bad paper may be eligible for VA benefits, but are excluded because they have not gone through the VA's character of discharge determination process. By VA's own accounting, only some 35,000 character of discharge determinations have been completed in the last 10 years. If you do the math, that's only 7% of the total 500,000 veterans with less than honorable discharge status. Of those 35,000 claims processed, only 3,500 qualified for VA benefits. That means in the last 10 years, only 0.7% of veterans with bad paper discharge were deemed eligible for VA benefits. Today's witness tells us this flawed system prevents thousands of eligible veterans from accessing VA benefits or health care. That means that 125,000 post-9/11 veterans alone, or 6.5%, go without care and benefits, compared to less than 2% of World War II veterans. That means that many veterans with military sexual trauma-related PTSD are left without benefits. That means that thousands of LGBT service members who were discharged with bad paper for behaviors interpreted as inexcusable misconduct are not utilizing VA services. As a former Navy commander, I understand the lengths to which a command will go to correct underperforming personnel. I believe the autonomy officers receive to ensure we uphold our standards and the military's good order and discipline. But we have a legal and moral obligation to look sympathetically at the circumstances behind less than honorable discharges. Creating solutions requires that we think about the ways to connect these veterans through outreach. It requires more training for frontline staff to understand that a less than honorable discharge does not automatically preclude a veteran from those benefits. It requires that we create a straightforward application process that veterans are aware of before coming to a VA facility. These changes can help us care for former service members in their time of need and connect them with VA resources to not only save lives, but help veterans become healthy and successful civilians. Thank you, and with that, I would like to recognize Ranking Mr. Boss for 5 minutes for opening comments.
Thank you, Chair Luria. I want to also thank everybody for being here to discuss the character of discharge, our COD determination process. Our nation's military has a code of conduct that defines military service as honorable or dishonorable. From my time in the Marines, I can remember the importance of honor to our military strength. Honor represents a Marine's commitment to act with respect to each other and in service to our country. Our ability to work effectively as a unit came from acting honorably. However, a service member's conduct can affect more than their military service. As you know, the dishonorable discharge can impact access to VA benefits. For example, according to the 1944 Servicemen Readjustment Act, veterans cannot receive disability compensation if they are dishonorably discharged. As a result, the VA must determine a veteran's character of service when a veteran files a claim for the VA benefits. VA decisions may be straightforward for a veteran with an honorable or dishonorable discharge. However, VA must take a close look for those with other than honorable or OTH discharges. This is because the service branches may issue an OTH discharge for misconduct or other reasons. I have heard concerns that the VA policy to review OTH discharges may set a higher standard than Congress intended. As a result, some veterans advocates believe that the VA practice may be denying eligible veterans VA benefits. If the VA is incorrectly applying the law, I am hoping that the VA will be able to share how they intend to address that. However, it is important to remember that it has been 76 years since Congress created the COD requirement, and since 1944, DOD has changed its guidelines on the actions that lead to certain discharges. Therefore, I'm interested in hearing whether Congress should update the law to better serve today's veterans. And I know that the full committee ranking member Rowe recently introduced a bill that would create a commission to review eligibility for care within the VA healthcare systems. Likewise, we should consider if we need to reform the COD process within the VBA. I would also like to access whether the VA's guidance and training has any gaps that could impact the quality of a COD decision. For example, veterans can overcome a bar to VA benefits if they had a mental health condition that led to the less than honorable discharge. VA's internal policies manual describes the additional development that must take place if insanity is an issue. However, the guidance is silent as to whether and what development may be needed to determine if the veteran had an in-service mental health condition that affected the discharge status. Thus, I would like to discuss ways the VA can improve its training and guidance to COD determinations. Finally, I recognize that some veterans may disagree with DOD's discharge decisions. I encourage these veterans to seek a discharge upgrade through their respective service branch, since VA cannot change a DOD's decision. Again, thank you for being here today, and I'm looking forward to having an informative discussion on the impact of the VA's COD process and access to the VA benefits. And with that, I yield back.
Thank you, Mr. Boss. Before we move to our panel from the VA, I would like to recognize Chairman Takano, the chair of the full Veterans Affairs Committee, and thank him for joining us and recognize him for 5 minutes for remarks. Please remember to pause briefly before you begin speaking.
Thank you, Chair Luria. Thank you for reminding me to pause. And I want to thank you for holding this hearing today to discuss the very important issue of discharge determinations at VA. First, I want to, but before I give my remarks, I do also want to address the loss of Vanessa Guillen. The circumstances of her death paint a stark picture of sexual harassment and abuse some women and men face in service. And even for those who survive, this kind of mistreatment can leave hidden scars that last long after their service. The first and second missions of VA are to provide clinical care and disability compensation for injured veterans. But we can't provide those services unless survivors feel safe going to the VA. And that's why VA needs to be a welcoming place where service members feel comfortable and respected. The issue we're here to discuss today is a critical part of ensuring VA's success. I was shocked to hear that a service member is now 4 times more likely to receive a bad paper discharge than during the World War II era. And while I recognize that some circumstances justify a bad paper discharge, the inconsistency in discharge status between eras of service, branches of service, and those who develop mental illness suggests that there are serious flaws in the system. A report from 2010 showed that Marines with PTSD were 11 times more likely to be discharged for misconduct than those without a PTSD diagnosis. Black airmen are 71% more likely to face a court-martial or non-judicial punishment than white airmen. Black soldiers are 61% more likely to face a general or special court-martial than white soldiers. Service members who report sexual harassment or assault are more likely to have bad paper discharges, suggesting a pattern of retaliation against MST survivors. Under Don't Ask, Don't Tell, more than 100,000 service members were discharged solely due to their sexual orientation, most receiving bad paper discharges. And after service, veterans with bad paper discharges are more likely to experience homelessness and be incarcerated. And some of our most vulnerable veterans are discharged under less than honorable conditions, but they are still eligible for VA benefits. Sadly, many of them don't realize this and never reach out to VA. Chair Luria, as you pointed out, of a population of 500,000 veterans with bad paper discharge, VA has only completed 35,000 character of discharge determinations in the last 10 years. That means only about 7% of veterans with bad paper discharge ever reach out to VA. And VA is very unlikely to deem that 7% eligible for veterans. And of the 35,000 character of discharge determinations VA made, 90% were denied. We know who VA is turning away, and unfortunately, it's the veterans who need VA the most. A study that came out just last year showed that veterans with bad paper discharge are 3 times more likely to experience suicidal ideation unless they recently accessed VA mental health care. That's a big unless. Mr. Goldsmith, I saw in your testimony that VA mental health care is the only reason you're alive to testify here today. I'm so grateful that you are here today. It's no exaggeration to say that VA mental health care is life-saving for veterans. And that's why we can't tolerate the exclusion of veterans like our Marines with PTSD, Black service members, or MST survivors. So I want to thank all of the witnesses for appearing here today to discuss this topic with us. I appreciate the comments of Ranking Member Bost and the Ranking Member, the introduction of his legislation. I look forward to hearing from all of the witnesses recommendations on how VA can care for veterans in need. Chair Luria, I yield back.
Thank you, Chairman Takano, and thank you for joining us today for this important discussion. We also have Ranking Member Rowe, the Ranking Member of the full Veterans Affairs Committee, here with us today. Dr. Rowe, I'd like to recognize you for 5 minutes for your opening remarks and also remind you to pause briefly before you begin speaking.
I know you'll be delighted to hear I don't have any opening remarks. I really want to hear the testimony, so I yield back.
Well, thank you, Dr. Rowe. And we will now move on to our first panel. I'd like to welcome our panel from the VA. We have Ms. Laureen Carson, Policy Assistant to the Director at Veterans Benefits Administration, and Mr. Garth Miller, Executive Director of Member Services at the Veterans Health Administration. Thank you for both being here today. Ms. Carson, I'd like to start by recognizing you for 5 minutes.
Good afternoon, Chairwoman Luria, Ranking Member Bost, and members of the subcommittee. Thank you for the invitation to speak today on the important topic of the Department of Veterans Affairs Character of Discharge Determination process. VA reviews an individual's military separation characterization when determining eligibility for VA benefits under Title 38. In the GI Bill, Congress determined that for veteran status, a former service member must have been discharged under conditions other than dishonorable. Congress gave VA the authority to determine whether a service member was discharged or released under such conditions and could be considered a veteran for VA purposes. At the time of this law, military discharges and the military justice system were vastly different than what they are today. Service members discharged with an offense under military law did not have a right to qualified legal counsel, and sometimes military commanders discharged service members in inconsistent manners. With the passage of the Uniform Code of Military Justice in 1950 and the creation of military review boards through Public Law 95-126, service members have been provided significantly more legal rights. Despite these improved safeguards, VA's authority to make determinations for VA benefits has remained largely unchanged since 1944. While VA does have authority to determine whether certain former service members can be considered a veteran for benefit purposes, VA's authority is limited by statute, which lists several kinds of conduct that are a bar to receiving VA benefits. Examples of statutory bars to benefits include discharge due to conviction by a general court-martial, absent without leave for more than 180 days, absent compelling circumstances, or discharge as a conscientious objector. VA generally considers any discharge under honorable conditions as satisfactory for meeting the basic eligibility for VA benefits. However, for certain discharges, such as the other than honorable or punitive discharges, VA must make a factual determination as to whether the discharge is under conditions other than dishonorable for VA purposes. VA claims adjudicators review the facts and circumstances surrounding the incidents that led to the undesirable discharge, as well as any supporting evidence furnished by claimants or third parties. When making these determinations, VA resolves reasonable doubt in favor of the former service member where the military service fails to provide VA with documents and VA considers any mitigating or extenuating circumstances such as family issues or the existence of mental health conditions. If VA determines an individual's discharge or dismissal to be disqualifying for VA purposes, he or she may still be entitled to treatment at a VA medical facility for disabilities that VA determines to be service-connected unless the individual is specifically subject to one of the statutory bars to benefits or a bad conduct discharge. VA also provides humanitarian care for certain conditions for former service members who are statutorily barred. VA has completed approximately 37,000 claims as of June, and that's over the last 10 years. These determinations are generally completed because a former service member files a claim for VA benefits or seeks medical care. Of these 37,000 requests, 5,800 discharges were considered honorable for VA purposes and thus qualified for the full range of VA benefits. Of the remaining 31,200, 11,000 were also disqualifying for medical treatment purposes. Because of the complexity and relatively low number of claims that require a discharge determination, VA is centralizing the processing of these claims to 4 regional offices at Winston-Salem, Nashville, Little Rock, and Muskogee. This strategy maximizes the Veterans Benefits Administration's operational efficiency, and more importantly, it enhances the accuracy and consistency of character of discharge decisions. VA is looking to improve the character of discharge process through regulation. VA considered the concerns raised by advocates and the veterans community and worked closely with the Department of Defense to ensure that any new proposed rule will be fair and equitable while still providing the military tools necessary to enforce good order and discipline. The Office of Management and Budget has recently concluded its review of the proposed rule, and it is now pending publication to the Federal Register. This concludes my statement, and I would be happy to address any concerns or questions from members of the committee.
Thank you, Ms. Carson. Well, thank you, and I recognize that we also have Mr. Miller present today, and we will certainly include you in the question portion. I will defer to the end and begin by recognizing Mr. Bost for 5 minutes for the first round of questions.
Thank you, Madam Chair. Ms. Carson, I know you were pretty clear on why this is, but I want to make sure that everyone understands. So why is it that the VA requires a COD of determination on the OTH?
Thank you for that question, sir. So Congress's authority to VA, it gave VA an intermediate authority, one that is not necessarily, that there was, well, can I back up for a minute? So the statutory bars that were originally in the law, when we go all the way back to 1924, included additional bars. Mm-hmm. And Congress removed some of those bars, but in that same instance gave VA this authority. Under former Secretary Hines, he, in trying to administer the program, he took those excluded bars and included them back into regulatory bars as a means of administering and making determinations on the intermediary classifications of discharge. And so they were those, what we have in the regulatory bars at 38 CFR 3.12 go all the way back to 1944. Okay.
So our staff did some oversight and review of VA's training and guidance on COD determinations, and believe that it could be improved and do a better job explaining how claims procedures should make and an objective COD determination based on willful and present conduct. So my question is that do you have and do you take and solicit feedback from employees and stakeholders about this training that they receive about COD?
Yes, we do.
Okay. If so, has this feedback been effective, and then are we then taking the information and not applying it? That's my big concern. That
So without getting into the specifics of the regulations, we are aware of all of the concerns about needed clarifications on willful and persistent misconduct. We have taken opportunities over the years, especially from 2018 to 2020. We have taken opportunities to update the procedural guidance to provide more clarification in the manual. We are working on the regulation, and in fact, we have enhanced the training since that time, and we have several modules of training that serve to better clarify that information for the employees. And then finally, we've also centralized this work for the most emergent and most complex types of character discharge determinations, and now we're going to centralize it further as a body of work to those 4 sites I just mentioned.
Okay. As this subject came up, and I think I've spoke to you about this, I know I spoke to staff about it, the concern that I have is when I was trained as an NCO, we were trained to understand what willful and persistent misconduct is. And so I'm trying to figure out then, how do you move that standard into VA where you can make that determination?
So one of the things that we don't do and we can't do as a Department of Veterans Affairs is re-adjudicate the character of discharge, the legal character of discharge determination as determined through the court system within the military. We can't do that work. We are not those experts at that. What we do is we look at those mitigating factors, the frequency of those factors, and other facts and circumstances, to include the veteran gets an opportunity if he or she would like to come before VA and share information as part of the due process procedural rights to be able to speak with us. But the legal definition that you're describing as it relates to the Military Justice Code is not the same standard that is in the regulation, and we are, as I said, seeking to clarify that.
So, and this is going to have to be fairly quick because I'm down to about 40 seconds here. We had the pre-hearing conversation with you, and you indicated that VA's interpretation of insanity is based upon the current accepted legal definition of insanity, which differs from Congress's original intent to create the insanity exemption in Title 38, USC Section 5303. Can you explain why the VA application is different and differs from what the law was that we created?
Thank you for that. So for clarification, VA makes independent analysis as to whether or not the individual meets the regulatory definition of insanity under relevant laws. Title 10 USC that governs the military service and VA's own 38 CFR 3.354 are what we use. VA also seeks medical opinions and medical clarification when necessary, as historical and/or current medical definitions for insanities may apply at the time of a particular offense.
Thank you for your answers, and with that, I yield back. I'm sorry, it went over time.
Thank you, Mr. Bost. I would now like to call on Chairman Takano for 5 minutes of questions.
Oh, thank you, Chair Luria. I thank you for accommodating me. My first question is to Ms. Carson. Ms. Carson, in your testimony, you stated VA conducted 2 special focused reviews in 2015 and 2016 to access the accuracy of VA's character of discharge determinations. And these reviews showed that 92% and 90% accuracy rates respectively. What do these special focus reviews consist of?
Thank you for that question, sir. The special focus reviews generally consist of an assessment and analysis of the claims process, whether or not the claims processors appropriately adjudicated the actions, gathered the right evidence based on duty to assist, provided any medical clarification or requested any medical opinions as that might have been necessary ensure that they went to the Department of Defense to gather evidence or to collect all records that might be pertinent and relevant to a person's claim. And it would look at the accuracy of those actions in leading to making the decisions applying applicable laws.
Well, can you tell me what about the training materials were those training materials updated? Can you tell me about the sort of training materials that were updated, whether they were updated?
So currently there are 5 particular modules that all VSRs must take, all claims processors must take. And within those modules, there's about 4.5 hours of training that is specifically focused on the character of discharge determination. Our talent management system has a module for the character of discharge itself, the process, the regulation, the procedural guidance, duty to assist, how to establish claims related to those, how to process the healthcare inquiries that come over to us when the person first presents at the VHA, and administrative decision processing.
Well, thank you for that. My next question is for Mr. Miller from the VHA. Mr. Miller, is there a separate form for a veteran can use to request a character of discharge review at VA that elicits information relevant to VA's determination?
Thank you for the question, Chairman Takano. Can you hear me through the mask?
I can, and it's fine if you look straight ahead at me. You don't have to look to your side unless that makes you feel more comfortable, because actually when you look straight ahead, I get the feeling you're looking at me.
Understood, Chairman Takano. In our room, you're over here, but I'll look up here so you can see me.
And we have to fix that somehow. That's been a feedback we've gotten from our witnesses.
Thank you for the question, Chairman Takano, and I appreciate and applaud the work that your committee as a whole and this subcommittee is doing on behalf of my fellow veterans. As a service-connected disabled veteran who receives outstanding care at VA facilities, it's been my career goal and my next career after active duty to make sure that we have standardized enrollment procedures and experience for all veterans, regardless of their character of discharge. I'd like to underline that determinations regarding character of discharge are not made at the local VA healthcare facilities. Those staff are not authorized to make those determinations, nor am I authorized to make those determinations. Those determinations are referred directly to the VBA for a determination, and I would just like to underline. Yes.
If I could interrupt just for a second, I only interrupt because I do have to get to another meeting. My question was, is there a separate form a veteran can use to request a character of discharge review at VA that elicits information relevant to VA's determination? Do you know about, is there a substantive form that exists?
Sir, that does not exist within the VA healthcare facilities. We submit a referral on a form 20-0986 to the VBA for that determination.
Is there any reason why we couldn't make those forms available at VHA?
It'll be a great photo when I
Are available?
I would have to take that for the record or defer to Ms. Carson.
Thank you. So if a veteran presents at the Veterans Health Administration and they have a character discharge that shows OTH or that shows an undesirable discharge characterization, then the veteran is at the VHA. They do have them fill out what's called the 1010EZ form, which is an application for healthcare. On that form, there are internal forms, as Mr. Miller mentioned, that then electronically sends that information to VA for us to make a determination so that, for instance, if they're giving them emergent health care under the humanitarian services criteria, then they can still submit that to us for a discharge determination, a character discharge determination. VBA's form is the VA form 21-526, which a year ago we upgraded that form so that, based on the new statutes pertaining to healthcare, so that any person who wanted to come into VA, whether they were seeking benefits or found a claim for healthcare eligibility, they could still use that form for a character of discharge determination.
Well, I know my time is probably running close to out, but it brings up the question to me about whether, so I do know that under humanitarian determination, under our national emergency, our pandemic emergency, veterans, regardless of their discharge status, can get COVID-19 related health care. It might even be broader than that. I don't remember what that determination was by the secretary, but it seems to me there's an opportunity to have many conversations about discharge review as veterans come in to the VHA or the various medical centers. And it would be helpful to know that our personnel are ready to have those conversations and that there's a form that they can fill out for a discharge review that people know about. So I guess, Mr. Miller, can you comment on the thoughts I've just had here about the extent to which staff can have those conversations at medical centers, whether people are aware of this form that Ms. Carson just mentioned?
Yes, Chairman Takano, thank you for the opportunity to respond once more. And I'd like to underscore that when other than honorably discharged service member presents to the VA at a VA healthcare facility with an immediate care for need, we provide essential treatment first and adjudicate administrative eligibility second. We see that as an administrative process that's secondary to providing the veterans with their immediate care needs, to include those who are in a mental health crisis. The 1010-EZ, I apologize, I thought you were referencing another form. The 1010-EZ form is available at the eligibility and enrollment desk. There are many ways for veterans to apply for enrollment and eligibility. And I would like to mention that 877-222-VETS, 877-222-VETS is the number that you can call the Health Eligibility Center under Member Services. Any veteran can call, any caregiver, any ally, advocate for veteran can call that number, 877-222-VETS. My team will answer that phone call and walk that veteran through the application process, even over the phone. Thank you.
But let's be clear that form allows for a request for a character of discharge review. That form, the form we're talking about now.
The 1010-EZ is an application for health care benefits.
So it's not about discharge review.
Filling out the application for health care eligibility begins the process of the discharge review. I hope I clarified that.
Thank you. I yield back, Madam Chair.
Well, thank you, and thank you, Mr. Takano, for taking time to join us today. I know that this is an important topic that we wanted to clarify. So in purposes of fairness, since Mr. Takano took more than the 5 minutes, I'm going to recognize Dr. Rowe. And Dr. Rowe, if you'd like to take 9 minutes as well, I will allot you that time. And for those members watching remotely, a reminder that if you have the screen on the view where you can see all of the participants, there is also a clock that is keeping time during the hearing. Thank you.
Thank you, Commander Laureen. I'm timing myself, and I'll try to stay within 5 minutes. And Ms. Carson, I want to thank you and Dr. Lawrence and the benefits for part of the VA for the incredible job you all have done in paring down the number of disability claims, not just this. And also, Commander Laureen, I want to thank you for having this. I think this is a very, very important hearing. And Ms. Carson, and I'm going to say this as a former member of the 2nd Infantry Division, 2nd Medical Battalion, Camp Casey, Korea, many, many, many years ago. I used to get sent to the first sergeant, sometimes a company commander, sometimes a battalion commander, behavioral problems. And I know Mrs. Carson mentioned good order and discipline that you have to keep. And some of these people who get discharged it was very disruptive to a squad, a platoon, an infantry company that we served in. And what I don't want to see us do I want to see people who deserve the care to get it, but I don't want to discourage bad behavior so you can get out, because I know how disruptive it was to unit cohesiveness. And Commander Loria said that, and I know that. I've seen commanders work very, very hard to try to have these folks fit into their units. So with that, Ms. Carson, could you tell me what changes that we can do to make your job easier to help make these determinations?
Thank you for that question. I do think that having these type of discussions and becoming aware of what it is we are doing to make things better, I think that those are kinds of things that can help us keep these relevant. There's been several roundtables. I had the opportunity back in 2017, 2018 to come here to speak to the Four Corners and to share about our efforts with the mental health initiative when we were trying to target and do additional outreach to reach the former service members as presented to us on the DOD list, which at that time was estimated to be 500,000 plus over all the years of service. And we tried to target some outreach then, but we also, that's when we set up the mental health initiative. I think our current secretary is still committed to these efforts to include our awareness on military sexual harassment, suicide prevention, our Prevents campaign, and several other outreach efforts to include more access to health care in order for us to get these things done. So these types of things, roundtable forums and things also help us get this work done.
Are there, Ms. Carson, are there any legislative actions, changes in the law that we need to do to make your job easier? Specifically, I know this is can be very subjective and can be very difficult to figure out. We back in the early 20s in my district, there's a Congressional Medal of Honor winner who got a dishonorable discharge. He was an alcoholic, struck an officer. So there are circumstances that certainly, and you're absolutely correct, you can't change a court-martial. That's a legal proceedings, and I certainly understand your inability to do that. But are there things that we can do right now legislatively, or can the VA do by rulemaking that would make these determinations easier? And one thing I want to say before I forget this is that there are folks out there like myself, because of my income, I can't get care at the VA. So we've got honorably discharged veterans who don't have access to VA care, and yet we're going to provide VA care for someone who was other than honorably discharged.
So thank you for that question. I would say, with regards to regulation, we're trying to do something with the regulation now. I explained earlier in a couple of the pre-hearing meetings, we have to continue to look at regulations often. We have to look at them more frequently. We need to let them match military times. With regards to the legislation, I'd say that I invite you to work with VA's legislative staffs to be able to determine what type of legislation might be necessary.
Well, we would like, I know my time's expired, and I would, I think the subcommittee needs to know that, so we can help you make your job easier. And with that, I yield back.
Thank you, Dr. Rowe. I would now like to recognize Mr. Sablon for 5 minutes.
This hearing, and I want to thank Mr. Cisneros for allowing me to take his time. Ms. Carson, I mean, sometimes I fancy just thinking if only we had the luxury of taking all the regulations, all the law, sitting down with VA and working with them so that we make things easier and more effective and efficient for our veterans. I know it's a fancy, it's a luxury we don't have. But Ms. Carson, one of the common concerns about the CODs, the character of discharge process raised by advocates, is the lack of specific guidance provided to veterans, to VASRs, about the types of misconduct that bars eligibility for VA benefits and leads to inconsistent decisions. So I don't really understand how a BSR can evaluate a claim without such guidance. In your statement, you mentioned the mandatory block of COD training required of new BSRs and 5 additional training modules on COD determinations. So does the COD training provide any guidance on the types of misconduct that would bar eligibility for benefits? And if so, what are those types of misconduct?
Thank you for that question. Yes, the training does provide, provides information pertaining to the statutory bars as well as to the regulatory bars. The training also provides examples and scenarios so that VSRs can understand the types of facts and circumstances and what the records look like, where they go to get information, how that information is to be viewed. And again, we are not legally going through and re-adjudicating or redetermining whether or not a court-martial, for instance, was in order. What we are doing is we're looking at that and seeing if there are any mitigating or compelling reasons why we should consider that service to be honorable.
Yeah. Let me understand this, because do I understand it correctly that a discharge would be honorable, general, dishonorable? So when BSRs look at a discharge, a DD-214, for example, they should be able to tell exactly what it is that is the discharge for the veteran. And if the decision on what the status or what the type of discharge is for that particular veteran is made by the Department of Defense, then how do your BSRs determine a different one?
Okay,
thank you.
All right, so one of the things, so there are 3 that generally are honorable for VA purposes or considered honorable, and most DD-214s would have honorable on it. General under honorable conditions. Those are all honorable discharges.
I get that, yes.
But then there are 3 others. There's the dishonorable, there's one that sometimes says bad conduct, and then there's the OTH. The OTH also has a reason. The DD-214 says OTH, and then it will have a reason. The reason could say in lieu of court-martial or other things that require us then to go to DOD to get the facts and circumstances and review those.
Okay, so BSRs actually can review it, and I'd be remiss if I don't ask a question pertaining to the people, the district that I serve, which is at one time was, if you sail across the ocean and come to my district, you would fall off a cliff, but we're so far away. So I must ask Ms. Carson, what services does the department provide to assist OTH veterans, particularly in underserved areas such as my district, the Northern Mariana Islands, the only district in the United States of America which has neither a CBOC or even a vet center? So I'm asking if you provide services to my district, my veterans.
So thank you for that. We do provide benefits and services to veterans on the islands, and I would also ask Mr. Miller to tell us about health care with regards to the Marina Islands.
Thank you, Representative Sablan, for the opportunity to respond as well. I understand that there is not a CBOC nor a vet center at that location. I believe your care falls under VA Pacific Islands healthcare system, centered in Honolulu, Hawaii, but I understand that they travel across many time zones to take care, and beneficiary travel is also a concern there. You asked specifically about other than honorable discharges and what services are available there. I would like to point out for your constituents and for all constituents that an other than honorably discharged service member presents to VA for healthcare treatment with an immediate care for need, even if it were Dr. Rowe, the ranking member, who exceeds income limits, if that is related to a service connection, or if it is emergency need, particularly in a mental health crisis, those options are available to those veterans. Thank you.
Yeah, thank you. Mr. Miller, I know my time's, Madam Chair, but I'm just going to also throw in another example for myself personally, where I was in the reserve component, Echo Company of the 100, and I'm in the 411 Pro. And in my search for my DD-214, I've got the only one I have is a 3-day intake at Fort Jackson. And I went to Fort Benning for my basic and AIT. But I do have a certificate of honorable discharge. So I don't know how to do that. I'm not asking for seeking services, but I'm sure there are others also who are missing. Madam Chair, thank you very much. And I'm over my time, way over. So I apologize, but thank you.
Well, thank you, Mr. Sablan, for joining us. I would now like to recognize Mr. Bilirakis for 5 minutes.
Thank you. Thank you. I appreciate it, Madam Chair. And I want to thank the ranking member as well. I also want to Representative Sablan. I don't know why you don't have at least a CBOC or a Veterans Center, but I want to be helpful in getting you one because you certainly deserve it. I have a question for Ms. Carson. Some advocates believe the VA should deem a veteran's discharge status an honorable for VA purposes and therefore eligible for VA benefits, unless the veteran's conduct warranted a dishonorable discharge. This seems to be a broader discussion about whether to expand on eligibility of services for those with other than honorable discharges. Would you respond to that? And, I'm concerned about the homeless vet that does not get the care that he or she needs. And of course, I'm concerned for all veterans. But if you could explain that to me and elaborate, I'd appreciate it very much. Thank you.
Okay, so when the Service Readjustment Act was passed, Congress removed statutory authority, but Congress also gave VA the authority to determine which intermediary discharges constituted conditions other than dishonorable. VA's administrator at that time determined that to include the bars to benefits that were excluded in the GI Bill as the best way to make those determinations for those intermediary discharges, which should be deemed under dishonorable conditions, and that included the other than honorable discharge, which was a classification that came later on that came post-law. So VA does believe that it is applying the law correctly, and VA does understand homelessness and higher risk for certain persons in that with those types of discharges, and as a result, VA has opened the aperture for health care for those persons suffering from emergent mental health needs.
Mr. Bilirakis, I believe that you are muted.
Oh, I'm muted?
We can hear you now.
Okay. Are we okay now? All right, thank you. Thank you, Madam Chair. Appreciate it. The question is for Mr. Miller, and hopefully Mr. Miller can hear me. We have heard reports that VHA employees are improperly turning away eligible veterans with an other than honorable discharge from the VA healthcare. As you know, there are many scenarios in which the other than honorable discharge still warrants VA care, and it was alluded to. How is VHA working to improve training to ensure that employees are effectively communicating eligible for care within the VA healthcare system to OTH veterans. If again, Mr. Miller can answer that question, I'd appreciate it.
Yes, I heard you, Representative Bilirakis, and I thank you for the opportunity to respond. I have a service-connected disabled veteran who, quite frankly, my life was saved by the VA. My career was made. My transition after my active duty service was made around the VA and serving my fellow veterans. It breaks my heart to hear that any veteran who is eligible was turned away at a VA healthcare facility. Since 2017, our organization has worked hard on the National Enrollment Standardization Team to provide robust standardized training for frontline staff who enrolled veterans into VA healthcare. This includes an entire training module specific to other than honorable discharges. We've also enhanced our knowledge management system, and this has been a popular topic with over 32,000 views on these articles related to other than honorable discharges. In addition to monthly calls and updates with the enrollment and eligibility staff at the VA healthcare facilities, we have also widely expanded our outreach to veterans as well as the frontline staff members to let them know that they may be eligible. I would underscore that no determination regarding character of discharge should ever be made at a local VA healthcare facilities, and our current and updated training materials and processes are designed to prevent that from happening to any other veterans. Thank you.
Well, thank you, but we've got to do a little better because I don't want to see any veteran turned away if they qualify for healthcare benefits. So very important, and I appreciate it very much, and I know we have to streamline the process. I look forward to working with you on that. Thank you, Madam Chair. I yield back.
Well, thank you, Mr. Bilirakis, for joining us for the hearing. I would now like to recognize Mr. Cisneros for 5 minutes.
Thank you, Madam Chairwoman. Thank our panel for being here today. Ms. Carson, I want to address a question with you now. I serve on both the Armed Services and the Veterans Affairs Committee, and I've kind of made it a point to really focus on the transition out of military service into the VA. And I was just wondering if you could elaborate on the ways the VA and the Department of Defense are currently coordinating to address the issue of service members with other than honorable discharges falling through the system that indeed need our support. Now, a lot of these individuals might be suffering from PTSD. How are we going after them and making sure that we are getting the support, and how are you working with DOD to do that?
Thank you so much for that question. So I will tell you that beginning in 2017, 2018, when VA began its mental health initiative at that time, we spent a lot of time speaking with DOD and trying to look at the issues of the other than honorable discharge. I personally spoke with the policy staffs of the joint branches about policies surrounding the OTH and character of discharge determinations, particularly because we wanted to stress issues with mental health. I know that DOD on their side have been working diligently to put in place processes with regards to when they are discharging persons that are suffering, checking whether or not they have any mental health issues, as well as we're ensuring on our side that we are providing more information in the TAP program and in our transition process for them. We also started a program just to check on veterans for 365 days after post-service that's called Solid Start. That allows us to do wellness checks to check to see if they need any services. Do they want to file a claim at that time? And at that time, we're hoping to target those individuals as they exit service to be able to identify persons with emergent mental needs. We're advertising our Veterans Crisis Line and the opportunities for any person having an emergent mental health need to be able to come to a VA facility. And then finally, we're also doing a lot more on our end to address issues of military sexual trauma and ensuring that there's more awareness and more of the ability for persons with those mental health crises to be able to contact local healthcare and VBA employees to file their claims.
Now, when you're doing those wellness checks, are you doing those to all individuals regardless of the type of discharge they have, or is it only for a specific group? Are you contacting those other than honorable, those individuals that were discharged with another than honorable?
I can take that back for the record and clarify that for you, sir.
Yeah, that would be good to know. I mean, again, right, these are individuals, a lot of them are suffering from, could be suffering from PTSD. It would be good to know that we are reaching out to them as well. You know, in the VA's testimony, you state that the VA has worked closely with DOD on the pending proposed role for character of discharge criteria. This is a rule the VA agreed to revise in early 2019, but has yet to put forth anything for public comment. Can you elaborate on this? When can we expect that?
So as stated in my oral argument, I was able to find out in the past 2 weeks that OMB has completed its review of the proposed rule, and it is pending publication to the Federal Register. There may be some delays because in COVID-19, it takes a little bit longer to get them through. I do understand that we committed to updating this rule in 2016, and here we are, it's 2020. We really, some of the challenges we had was some of the efforts that we've engaged in. First and foremost, rules take a long time. Our first efforts were to clean up our training and to clarify our M21 procedurals manual to our staff. It was also to do joint training, and I participated in the training on with the mental health initiative to the frontline, all the frontline staff at the VA medical centers, and I personally attended several training classes to ensure that they understood how to use the systems, how to identify whether we made a decision or not, and when to refer them. We streamlined some of our policies between us internally to ensure that those that were in the system, we had a significant backlog. In 2018, I read that it was taking us over 303 days to process these. Today, it takes us about 170 days to process them because of the due process involved in the hearings that are involved. But I will tell you that we've been working with them. We worked with DOD. We met with them on policy implications to ensure that we don't degrade the good order of military service.
All right, with that, I yield back.
Thank you, Mr. Cisneros. I now recognize Mr. Watkins for 5 minutes.
Thank you, Madam Chair. Ms. Carson, please detail whether employees are required to conduct additional development to identify potential mitigating factors when a veteran claims that their dishonorable discharge was a result of a mental health condition.
So oftentimes when veterans present to us, and once we've told them that we're making these determinations and they have the right to due process to be heard and face-to-face, many veterans elect to exercise that right and will request a hearing so that they can share the facts and circumstances surrounding the issues involving their reason for discharge from service. With that, if they may tell us about suffering from a mental illness, they may show us information or documentation that they have about having gone to a sick call or having had some kind of interaction subsequently at the service that's closely related to service. They may have gone and seen a doctor. We get that information, and oftentimes we'll use it. When they come to us and they're telling us that they have when we can see in the record that there was a mental health issue, that's a mitigating factor. That's an easy one. That's one in which you would be writing a person honorable for VA purposes, at least if not honorable because of other factors in the record, you would make them eligible for health care because the law allows us to do that.
What if it's a general or other than honorable discharge?
If it's a general other than honorable discharge, we would still get the facts and circumstances surrounding that issue and review all those records as well.
And can a veteran request a character of discharge determination that's related to an underlying claim for VA benefits? And if so, please describe the process.
Sure. So our process, if a person files a claim for benefits, and even if they go for health care and then realizes that their case may be service connected, it becomes a claim for benefits. They would fill out the 526 EZ. With that, we would exercise, we would send the veteran a letter, and we would submit request that we would give our duty to assist the veteran and request any and all evidence surrounding not only the discharge but the service-connected issues. And we would get we have a responsibility as an organization to go to DOD to request all pertinent records and all federal records. VA does that for the veteran. We also, anytime we go out for those records, we simultaneously notify the veteran that's what we're doing in case he has any in his or her possession. And we would then adjudicate that claim. So if it comes in with a claim, we look for all aspects to see whether we can make them eligible, honorable for VA purposes, or whether we could, if they're not honorable for VA purposes, for benefit purposes, they could still be could be eligible for health care because they had a service-related injury in that period of service, or because they're suffering from a mental health condition.
Ms. Carson, now hold tight because there's 5 acronyms in this sentence. Please explain how VBA is working with VHA to timely complete COD determinations for OTH veterans seeking VHA care.
So thank you for that question. I will tell you that some of the things that we have done recently is shore up our systems. One of the things that, as I said, I stated, I was able to participate in the training of the VHA frontline workers on how to read information about our determinations. And VHA Frontline is able to see that in VA systems electronically without having to call someone to try to find it out. They can see it real time as they see a veteran. We also have shored up our process internally where it used to be that they sent us over a 10-7131 form. It would be a paper form. It would go through a process. We now do all of that electronically so that when they have a referral to VA, while they're providing treatment, we're also doing the character of discharge determination. And specifically for those that that are in VHA's care and National Cemetery Administration, we make sure that we send those to specific offices of employees who work those particular issues.
Thank you, Ms. Carson. And Madam Chair, I yield the balance of my time.
Thank you, Mr. Watkins. Ms. Underwood, you are now recognized for 5 minutes.
Well, thank you, Madam Chairwoman, and thank you to our panel of witnesses. Right now, about 500,000 veterans lack access to VA benefits and health care as a result of bad paper discharges. This includes 125,000 post-9/11 veterans, as well as more than 100,000 service members who were discharged with bad papers because of their actual or perceived LGBTQ status. Following the repeal of Don't Ask and Don't Tell in 2011, the DoD issued a memo outlining the rules for upgrading discharge status for service members who were discharged based on their LGBTQ status. But an Associated Press review of DoD data in 2016 found that only 8% of those veterans eligible to apply for a status upgrade had done so, right? So that they had applied. Ms. Carson, those numbers are from 4 years ago now. As of 2020, what percentage of those veterans who are eligible to apply for an upgrade in status have done so?
I would have to take that back for the record. I am not aware of any stats with regards to those percentages.
Okay. And then what percentage of eligible veterans who were discharged because of LGBTQ status have applied for an upgrade, and how many of them have actually received one?
So that is also information that I do not believe our systems categorize information in that manner with regards to the character of discharge determinations. We don't have a percentage of same-sex eligible veterans who have filed claims. We don't keep our records in that manner.
Okay, it's my understanding that that would have been reflected in some way on their original discharge from DoD.
I am not aware of a block on the discharge determination that would identify them as male, female, or LGBTQ.
Okay, we will follow up with you all in writing after this hearing. But veteran advocates report that many veterans who have had bad paper discharge due to LGBTQ status don't know that they're eligible for an upgrade. Ms. Carson, what outreach work or information campaigns does VBA have in place to educate this part of the veteran community about their eligibility for an upgrade?
So in 2018, when we were made aware by DOD of the 500,000 plus former service members with OTH or bad paper discharges, VA did embark on a campaign. It was a VA-wide campaign. VHA did a lot of it because it was related to the healthcare, and I'll let Mr. Miller talk about that campaign.
Thank you, Representative Underwood, for allowing me to also respond to that. My office led the mailing campaign of over 475,000 letters to known former service members with other than honorable characters of discharge beginning in 2018. The purpose of this mailing campaign was to inform these former service members with other than honorable discharges that they may now be eligible for services at the VA due to new mental health legislation.
So,
we know that
I appreciate that, but that is not a response to my question, because my question was about informing them about an eligibility upgrade, not services that they might be available to them regardless of their discharge status. And so, I think that, we are happy to receive that information from you for the record, but we know that many of our veterans face heightened mental health and suicide risks as compared to civilians, and that many of these risks are connected with their time in service. And while there are services, regardless of their discharge status, we want our veterans to be receiving all the care that they're eligible for. And at this point in time, we know that these folks are not. Studies demonstrate that service members, especially those who deploy to combat zones or who experience military sexual trauma, are also at higher risk of PTSD. Per VHA's most recent annual suicide prevention report, suicide rates among veterans using VHA services have been found to be affected by economic disparities, homelessness, unemployment, disability status, and more. And that's for veterans currently using VHA services. Of course, this doesn't include veterans ineligible for VHA care because of their character of discharge. I understand that my time is quickly expiring, so I'm going to follow up with Ms. Sedor about some risk factors like economic hardship and homelessness around these bad paper discharge and the like. But at the end of the day, we care a lot about this segment of our veterans community. We want to make sure that they're getting connected with all the services that they're entitled to. And I thank you all so much for the work that you do and for appearing before our panel today. And I yield back.
Thank you, Ms. Underwood. I will now recognize myself for 5 minutes, and I really appreciate the questions and the line of questioning that Ms. Underwood undertook, and I want to kind of follow through with that because we understand that there were approximately 500,000 veterans in the period from World War II to present who have this type of discharge and who are eligible for at least a review of their character of discharge to determine if they're eligible for VA benefits. A lot of questions have been asked about what you've done, and you just referenced the fact that you sent a mailing to about 476,000 veterans. What is your assessment of the effectiveness of that? Because if you had 500,000, only 35,000 have applied over 10 years, are you doing enough to reach these veterans? And we frequently hear that a lot of the veteran suicides, we tragically hear that there's about 22 veteran suicides a day, that many of those people have never presented themselves to the VA for care. One of the largest problems being a misconception that because potentially their character of discharge didn't allow them to have that care. So communication seems to be a huge issue, and you're referencing a letter you sent in 2018. Is this a one-time effort? Are you planning to continue a persistent and deliberate outreach to make sure that you continue to reach veterans every day? Can you comment on that?
Thank you, Commander Loria, for not only your service, but for the opportunity to continue my response. That letter was one of many of a multi-channel outreach campaign that began in 2018 and continues.
So before you go on, what is your measure of effectiveness? If you send 100,000 letters, how many people do you expect to contact you back? I mean, do you have a way to determine if you're being effective in the ways you're communicating?
Yes, Commander Luria. We've had, since 2017, 16,000 former service members with other and honorable discharges that applied for VA health care since the laws have changed.
And what
We
year was
also-
that? Since 2000?
2017.
Okay, so
when the
only
laws-
double that number have been reviewed in 10 years. So is there a significant backlog? Can you comment on how many are awaiting review?
I'll pass to VBA on this one.
So just so that the issues aren't mixed, the mailing for the healthcare that went out for healthcare, those persons didn't all necessarily come in and file a claim for VA benefits, but they did. Some did take advantage of the healthcare. They also had some respond to the letter that was sent. With regards to claims, right now, currently we have for 2020 we have 4,101 claims pending review. That's for benefits, for claims for benefits.
That's where a characterization of discharge determination is required before it can move
Yeah,
to the
those are
next step.
COD, yes.
And what approximate amount of time does it take you to get through a 4,000 claim backlog?
Right now, the
Approximately
average,
a year based off your numbers of 35,000 in 10 years.
yeah. So, and as I said, in 2018, it was taking us an average of 303 days to process these. Our average days pending right now is 172 days. It does take some time. When we gave you the numbers in March, we had 35,000, and since then we're now at 37,000. So during this COVID-19 period where we couldn't get any federal records and we could not do examinations, we did take a concentrated effort to look at the workload and to reduce that backlog that was there. So we got another 2,000 claims done in this time period. The claims are pretty old. As I stated, they require multiple outreaches to go get the evidence, to gather the evidence, and so it does take a little while. Plus, it takes us looking at what the veteran reports were the fact and circumstances and reconciling that information. So, it's improving. It can get better, but we are working on it.
Well, thank you for the update, and I would like to continue for this committee to get updates on the progress, the number of backlogs, and the average amount of time it takes for one of these claims to be processed. A big responsibility of this subcommittee and the committee as a whole is to make sure that you as the VA have the resources you need to tackle these challenges. Are there any additional resources that you need in this area in order to help with either the outreach and reaching more veterans, resolving the claims in a timely process, or coordination with DOD? Because myself, Mr. Cisneros, Mr. Bergman, there's several of us who are both on this committee and the military personnel subcommittee, and would also like to facilitate that DOD to VA issue if there are hurdles there that we can help accomplish.
And VA appreciates that, and we'll take that back for the record and get something back to you about any needs that we might have.
Well, thank you. And thank you, Ms. Carson. Thank you, Mr. Miller, as well, for participating in this panel. I believe I was the last person on this panel as far as the round of questions. And so we will be moving on to our second panel. I would ask that we just hold tight for several minutes. We want to make sure to clean the witness table for our next group in precaution for COVID. And thank you again for participating today. And also thank you to our members. We hope that you will stay with us for the next series of witnesses. So we will take about a 2 to 3 minute pause. Okay, as we are currently experiencing some difficulty hearing from Ms. Sater and Ms. Montalto, we will work behind the scenes to correct that and recognize Mr. Goldsmith for 10 minutes, and we will certainly come back to the other witnesses to allow them to participate.
Thank you, Commander Loria, Ranking Member Bost, and distinguished members of the committee for holding this hearing today and for inviting me to testify. I want to extend my sincere appreciation to those staffers who organized this hearing, as well as to all the essential workers who made my being here today possible during this pandemic. In light of the serious threat of COVID-19, I would not be here today in person if I did not believe that the subject of this hearing, the VA's failure, America's failure, to help veterans with bad paper, was deadly serious. And it is deadly serious. Due to their physical and psychological symptoms and the nature of their separation from the military, veterans with less than fully honorable discharges are often isolated from the military and veterans community and are more likely to be homeless, to suffer from substance abuse, to go without treatment for physical and mental injuries, to become incarcerated, and ultimately to die by suicide. I am a veteran with bad paper. In addition to the trauma of war, the experience of being discharged with a less than fully honorable discharge and the resulting denial of VA benefits has shaped my entire adult life. On May 15, 2005, my platoon was nearing the end of our routine patrol through Sadr City, Baghdad, when we were diverted away from returning to base. May 15th wasn't the first time that we got a call to assist Iraqi police officers as they picked up the bodies of murder victims to bring them to the morgue. This wasn't the first time that it was my job to photograph the bodies, take close-up photos of the lifeless faces, try to determine the cause of death, try to discern their identities, and to make futile attempts to come up with an explanation for the killings that I can include in my intelligence report. When we pulled up to the trash dump, it was apparent that this time was going to be different. Having heard about bodies being found, women and children from the city were already pouring onto the scene. On the one hand, they're hoping that it is their missing husband, brother, father, who's being found so that their family can finally get some closure. On the other hand, you know, they're obviously hoping that it's not their family member who's been murdered, still hoping that they're alive. There's a small flatbed pickup that had already had a pile of bodies in it. I looked down into a pit and saw men tugging at the arms of a limp corpse that was only partly exposed, while other men attempted to dislodge the buried legs from the earth. There was a dead and decaying donkey to my left. Maggots squirmed under its skin. These bodies were buried in an unmanaged trash dump, which is surrounded by pools of raw sewage. We were told that there was something like 2 or 3 million people living in poverty in Sadr City, Baghdad, and that's where much of their waste ended up. I started performing my regular duties, gathering intelligence, writing down what I saw, talking to the police and witnesses through the interpreter, trying to figure out what the hell happened, hoping that somehow we, the U.S. Army, could be a force for justice for the victims of this massacre. A second truck was brought up to be filled with bodies. There were over a dozen in all. It was time for me to take pictures. I saw packaging tape that had been wrapped around their heads, covering their eyes, pulled tightly across their mouths. I saw signs of torture, gunshot wounds that looked like they were intended to injure but not kill. I saw coagulated blood, still fresh enough to drip, sling from one of their noses and onto me. I saw flies landing on the faces of victims of torture and murder. The buzzing was everywhere. As I took pictures, flies that had just been on corpses, a rotting animal, trash, and sewage landed on my own face. In the heat, they seemed extra fast, and they still landed quickly to sip moisture from the corners of my eyes, my nose, and my mouth, no matter how much I tried to swat them away. What I've described to you is just a small fraction of one single day after my patrol ended of my year-long deployment. I was 19 years old. A year later, while I was home in the U.S., I became an alcoholic. My roommate would frequently find me passed out in the shower under scalding hot water. I was trying to burn the smell of May 15, 2005, out of my mind and flesh, inside and out, because the rotten smell of death on top of trash, soaked in sewage, followed me home. I could still feel the flies landing on my face. My military career still went well, despite the things that I went through. I was promoted to the rank of sergeant in just about 2 years in service. Not only did I continue my duties as a forward observer, but I also was made communications sergeant for Alpha Company and charged with maintaining millions of dollars worth of equipment. I graduated from Warrior Leaders course among the top of my class. In May 2007, after struggling for months to obtain mental health treatment from the Army, I took a handful of Percocet and a bottle of vodka and tried to end my own life. Thankfully, my best friend and roommate had recognized my downward spiral and called the police. I was found unconscious and was rushed to the hospital. 3 months later, I was kicked out of the Army with a general discharge, a status that cost me my eligibility for the GI Bill. After having an otherwise stellar career, being well-liked both by my command and my peers, and exceeding every performance standard that the Army ever put in front of me, a staff sergeant issued 2 counseling statements to me, one for malingering, which is a medical diagnosis, and he had a high school education, and the other for missing movement, because my suicide attempt happened the night before my second deployment to Iraq. Those 2 counseling statements were all that it took to quickly kick me out of the Army and change the rest of my life. I found myself back in my childhood bedroom with no job, no hope, suicidal, drinking heavily nearly every day. The social stigma of my discharge status meant that I was a pariah among the men that had months before been like brothers to me, who I had lived with and shared everything with for the better part of 4 years. My childhood dream of serving in uniform turned out to be a nightmare, and one that I couldn't escape, a nightmare that would follow me everywhere that I went. Because the Army interpreted my suicide attempt as an act of misconduct, not only did I could I not use my military experience on my resume, I didn't even qualify for unemployment insurance in the state of New York as the economy collapsed in 2007. I was eventually diagnosed with PTSD by the VA, and ever since I've been in the process of recovery. With a general discharge, I still qualified for VA health care, and that access to VA care is the only reason that I'm alive. I was lucky compared to the veterans that we're here to discuss today, those with other than honorable discharges. They have been systematically denied essential health care services because the VA reinterpreted the words that Congress put into the law with the 1944 GI Bill of Rights to reduce their workload and to save money. As of a couple years ago, there were 505,000 veterans living with other than honorable discharges in the United States. Those veterans have, for the most part, been denied all essential services, not just the GI Bill, but VA health care. My discharge made me ineligible for many of the fringe benefits that the average veteran receives. I've been barred from applying for most scholarships and fellowships that are dedicated to veterans. I didn't qualify for New York State's Veterans Tuition Award, and without the GI Bill, I've accumulated tens of thousands of dollars of school debt. But being public about bad paper has also led hundreds of people who've endured similar experiences to reach out to me and ask for help. And that's the other major factor that led me here today. It's been 13 years since my discharge from the U.S. Army. Since then, I've learned to manage my PTSD. I've gone to school, and after working my ass off, I managed to graduate from Columbia University with honors this past May. I've started a nonprofit called High Ground Veterans Advocacy, where I train veterans to use their military experience and personal stories to motivate Congress to enact legislative reforms. I came up with the budgetary trick to invent the forever part of the forever GI Bill with your staff, ensuring that today's service members don't lose their eligibility because of some arbitrary time limit. I've intervened in more suicide attempts than I can count, answering phone calls, emails, text messages, and social media messages at all hours of the day and night from strangers and friends alike, many of whom should be calling the VA, but they've been denied care. I've become the face of bad paper, and with my story published in more than a dozen mainstream outlets and trade publications, I've been invited by both the Obama and the Trump administration to visit the White House to witness the signing of legislation that I've played a key part in advocating for. And it still took 12 years for my discharge to be upgraded by the Army. Although through all this frustration, I spent this time learning that I'm not alone and that there are major systemic flaws that allow patriots like me to serve and sacrifice for this country, only to be discarded like trash. Since I learned about this country's abandonment of veterans with bad paper, it's been my primary focus in life to see that things are made right. In 2016, I walked into a meeting in Senator Tom Tillis's office and met with his senior military advisor. After telling him my story and urging his boss to sign on to the Fairness for Veterans Act, he looked me in the eyes and said, "Son, you're doing the Lord's work." That man's name is Robert Wilkie. But as Secretary of Veterans Affairs, he's failed to prioritize veterans with bad paper. I can't figure out why, when given the chance, Secretary Wilkie won't pick up the torch and do the Lord's work by helping make our most vulnerable veterans a priority at the VA. The VA already has the statutory authority to care for veterans with bad paper, and more than enough reason to comply with the congressional intent of the authors of the original GI Bill of Rights. So I beg you, please do something big. Drag your colleagues along with you if you have to. Amend the GI Bill to at least protect all veterans with bad paper, as I was, to help us move forward in life. This is especially important during the economic crisis that we're in today, which is even worse than when I got out in 2007. Hundreds of thousands of veterans like me have been issued lifetime punishments in the form of a denial of the very same earned benefits that are designed to help veterans put their lives back together after their time in service. Please, ladies and gentlemen, end this national tragedy. And thank you for the extended time. I sincerely appreciate you holding this hearing. I've been waiting literally 12 years for this opportunity, and I look forward to answering your questions.
Thank you, Mr. Goldsmith, and thank you for sharing a very personal and very long story that has gotten you to the road of being here today. So we appreciate your advocacy and look forward to continuing to work with you. I'm going to go back to our previous witnesses and see if we've resolved the technical issues that we have. Ms. Sater would like to recognize you for 5 minutes. Excuse me, for 6 minutes.
Thank you, Chair Lori, Ranking Member Bost, and subcommittee members. Thank you for your attention today on this important issue. The VA is denying benefits to those veterans most in need. Vets with less than honorable discharges are twice as likely to die by killing themselves. Their rates of homelessness and incarceration are disproportionately higher than those with honorable discharges. According to a government report, nearly 1 out of every 4 service members diagnosed on active duty with PTSD or traumatic brain injury are given an other than honorable discharge. To give you a sense of this veteran population, I'll share 2 of my clients' stories, though I've changed their names to protect their privacy. In 1950, Mr. Sanchez was only 18 years old when he rose to the rank of sergeant during his combat deployment in the Korean War. He endured shrapnel injury, earning him the Purple Heart, and then returned back to the front line. When he was finally returned stateside, injured physically and mentally, he began drinking heavily. On a night out with fellow soldiers, he was asleep in the back of the cab when his friends decided to rob the driver. Despite statements in his military record from those friends that he was not involved in the crime, the Army kicked him out with an other than honorable discharge. In another case, Mr. Ford was stationed in Germany on his way to Iraq. It was 2005, and he went out celebrating his 19th birthday when fellow soldiers attacked him. They raped him and left him for dead on the street. The beating he endured was so severe that he required facial reconstruction surgery. When his staff sergeant visited him in the hospital, he laughed in Mr. Ford's face about what had happened to him. After being released from the hospital, Mr. Ford decided he didn't feel safe going to war with these men, and he went AWOL instead for 6 months. When he turned himself in, he received an other than honorable discharge. These are 2 of the hundreds of stories that I have heard from clients that we have helped at Swords to Plowshares. We're a team of attorneys who provide pro bono representation for homeless and low-income veterans before the VA and Department of Defense. We focus our resources on those with less than honorable discharges because the VA, as a regular practice, shuts its doors on veterans like Mr. Sanchez and Mr. Ford. VA character of discharge determinations, the process by which it decides whether bad paper veterans should be found eligible, is a broken system. Let me be clear, the VA does a lot of things right. They provide exceptional mental health care and generous monetary benefits to those with service-related injuries. that these life-saving benefits are being denied to thousands of veterans because of misconduct in their record, very often related to their struggles with PTSD and TBI. Perhaps most alarming, Black soldiers and airmen are 61% and 71% more likely, respectively, to face a court-martial or non-judicial punishment, leading to a higher risk of getting a VA disqualifying discharge than white veterans. How can the VA fix this? We have 4 recommendations. First, the VA needs to provide veterans, their advocates, and its own adjudicators with clear guidance regarding what misconduct constitutes a bar for benefits. Currently, there is little guidance, and the outcomes are incredibly inconsistent. For one example, in Los Angeles at the VA, they approved only 15% of these eligibility cases in 2018, yet 130 miles south in San Diego, that approval rate is nearly 40%. Second, the new guidance needs to reflect congressional intent. Currently, the VA is excluding vets for minor misconduct when Congress only intended that those with severe misconduct be excluded. Just last month, we received an eligibility denial for a client we're representing at Swords because the adjudicator was convinced that testing positive one time for drugs constituted a crime of moral turpitude. We recommend that only discharges due to court-martial or those in lieu of court-martial require an eligibility review at the VA. Third, the VA needs to codify that mental health is a mitigating factor in deciding these cases, so those with service-related PTSD and TBI and military sexual trauma survivors are given greater leniency in their reviews. Fourth, the VA needs to tell veterans about their potential eligibility. As you've heard today, hundreds of thousands of veterans have separated with less than honorable discharge, and only a fraction have been reviewed for eligibility. It should be an absolute given that Purple Heart recipients like Mr. Sanchez and military sexual trauma survivors like Mr. Ford are considered veterans at the VA. Yet Mr. Sanchez waited 63 years without any benefits from the VA until they finally found him eligible after a 3-year wait from initial application at the age of 83. This should be unacceptable, but this is the norm. The DoD is separating vets with bad paper at a higher rate now than ever before. While the VA has no control over how the DoD dispenses military justice, they do have the authority to help these veterans today, and they are choosing not to. These outcomes are unjust, and our vets deserve better. Thank you.
Ms. Sater, thank you for your testimony. I appreciate you offering those recommendations. I do just, as a reminder, want to say that the military has a zero-tolerance policy for drug use, and I know that you included that in your comments and examples, but I do not think that that is something that this committee would undertake as a consideration. I would now like to recognize Ms. Montalto for 6 minutes. Ms. Montalto, can you please unmute yourself?
I'm obviously having technical difficulties today. Thank you. Chair Luria, Ranking Member Bost, members of the subcommittee, thank you for this opportunity. I am an attorney and clinical instructor at the Veterans Legal Clinic at the Legal Services Center of Harvard Law School, but I'm also on leave currently to teach at Yale Law School's Veterans Legal Services Clinic. In both capacities, my work focuses on veterans with bad paper and helping them gain access to the care and support that they need. This committee has the opportunity now not to repeat the mistakes of the past, but instead to uphold the legacy of the World War II era Congress that guaranteed access to basic VA care and services for nearly all returning service members. What was that historical mistake that shouldn't be repeated? After World War I, our government failed properly to care for returning service members. There was no centralized, comprehensive benefits and healthcare program to assist World War I veterans in their transition. And as a result, they suffered untreated wounds and mass unemployment. This ultimately led a bonus army of tens of thousands of veterans to walk across the country and march on Washington to demand fair and adequate treatment. While the government eventually agreed to provide some assistance, for many, it was too little, too late. And importantly, many veterans, including those who did not have honorable discharges, were excluded. The World War II era Congress knew of that recent history when, in 1944, it began making a plan for the 16 million returning service members. and chose to make an expensive set of benefits, healthcare, disability compensation, education, home loans, available to them to help them reintegrate and succeed in their civilian lives. Congress thought that carefully about whether veterans who did not have honorable discharges, such as those with other than honorable discharges, should be eligible for these benefits and considered a range of options. In the end, Congress adopted the position proposed by Harry Colmery, former national commander of the American Legion, who originally drafted the 1944 GI Bill. That standard was eligibility for all former service members who were discharged under other than dishonorable conditions, which expressly can include veterans with bad paper. Why did Congress settle on this standard? They knew about service members who had experienced combat stress or shell shock, and who had started drinking to deal with war wounds, and who then were kicked out less than honorably because of related misconduct. And Congress thought that while it may be appropriate for them not to be in the military anymore, that the government still should care for these veterans. As Harry Colmery explained, we use the language under conditions other than dishonorable because we are seeking to protect the veteran against injustice. We are trying to give the veteran the benefit of the doubt because we think he is entitled to it. Some at the time argued against this standard, including the service branches. They sought instead to reserve VA benefits only to those with honorable discharges. Congress, in its wisdom, deliberately chose otherwise. It's important to remember that nearly half of members of Congress at that time had served in uniform, so they made this decision not because they did not understand military life, but instead because they understood it better than most. And not only did Congress choose an expansive eligibility standard, Congress also decided that VA should make the eligibility determination, not the service branches. Congress saw the military and VA as having different missions. The military had to defend the nation, maintaining good order and discipline, and VA must care and support veterans in their post-service lives. Congress thought that the person deciding whether a veteran should be able to get treatment for the wounds of war should be someone far removed from the heat of battle. Over time, this history has been forgotten, and agency rules and practices have overtaken the words and spirit of Congress's law. Now, despite the law in the books, VA routinely denies care to veterans with bad paper, oftentimes not even allowing them simply to submit an application. These exclusionary policies and practices fall especially hard on certain groups of veterans: those who've served in the post-9/11 era, those who are enlisted, veterans of color, and veterans who have mental health conditions such as from combat service or military sexual trauma. And while healthcare is important to all Americans, especially now in light of COVID-19, access to healthcare is especially critical to veterans with bad paper. As Chair Takano pointed out, a recent medical study found that veterans with bad paper have 3 times the risk of suicidal ideation. But that same study also found that the increased risk was entirely eliminated if the veteran had recently accessed VA mental health care. There is no other way to put it. VA care saves veterans' lives. And if this committee is serious about reducing veteran suicide, the only way to do so is by ensuring access to care for veterans with bad paper. In closing, I urge you to uphold the mantle of the World War II Congress and ensure that all those who served can access the care and support that they earned. Thank you, and I look forward to your questions.
Thank you. I will now recognize myself for 5 minutes for questions, and I'd like to go back to Mr. Goldsmith. So we talked a lot in the first panel about outreach to veterans. Can you talk a little bit about your experience? And you said you interact with many veterans who find themselves in the same situation. Can you talk about whether you find that outreach to be effective? Is it clear? Does it provide people the information they need to try to seek care when they previously were not eligible or believed they might not be eligible due to some changes over time?
So I think thank you for the question. I think that your panel here is presenting something that you don't often see. You usually have critics of the VA or defenders of the VA. We are both. We realize that the VA is key to saving these veterans' lives. But I can tell you that as an avid consumer, as a veteran advocate, I'm an avid consumer of all VA material. And I have only been aware of 2 campaigns to do outreach, which is the mailing campaign, which they didn't get to talk about the numbers, was not very successful. They had a lot of, I think, maybe hundreds of thousands, if not tens of thousands, of letters that got returned. They also posted on their VA blog, which people like me read. I can't say that many of the people I served with read the VA blog. and they did a 1 or a 2 hour Facebook Live where they answered questions. That's the only outreach that I'm aware of. And I can tell you that homeless veterans are not getting a letter in the mail. And veterans who are discharged with bad paper are much more likely to be homeless. Veterans who are homeless are not likely to be on Facebook, to see that Facebook Live. So there is much more that can be done, and Congress shouldn't leave it up to the VA to do it. Congress needs to make the VA do it. It needs to be through legislation.
And through the work that you do through Veterans Advocacy, how frequent are these requests that you receive? Not necessarily the frequency, because I know you specialize in that specific area, but how much of a lack or delta of information versus the facts of these are the policies, procedures, process is there? I mean, when people come to you, they may think, well, I have this other than honorable discharge, I'm not eligible.
Sure.
How much hand-holding, for lack of better terms, is required from someone who's been through the process like you have yourself to actually get them through the process successfully?
So I'm not a lawyer. I cannot assist people with their cases, with their claims. I'm not qualified to do that. What I am is a fellow veteran, and I'm willing to help my sisters and brothers who have signed on the dotted line. I don't care what their characterization of service was. When you sign up for service, you're rolling the dice with fate. You could be rewarded the Medal of Honor, or you could be a homeless veteran. It really depends on just the circumstances that you land in. It's not about you. I think most veterans, when they're being honest, will tell you that. Now, the VA Form 1010-EZ is an application to get enrolled in the VA system. If you've been told since your discharge, whether it be last year or back in 1970 towards the end of the Vietnam War, that you are not eligible for VA healthcare, you're not going to apply, because you've been trained to expect rejection from the VA. That's why we keep harping on the idea that there needs to be a specific form that says, I, the veteran, am applying for a characterization of discharge review. That also gives you, Congress, a form that you can track and you can hold VA accountable. If there is a dedicated form, it's easy to siphon out, and you can find out, is the VA, like the Army, like the Marines, denying more black veterans access to benefits than white veterans? I think that those kinds of disparities are important, and that's why we need a dedicated form. Now, as far as the hand-holding that I need to do, I can guarantee that tonight, Facebook Messenger, Twitter, I'm going to be getting all sorts of messages. I have a uniquely spelled name. I'm easy to find. I'm going to be getting emails from veterans all around the country who don't trust the VA, who unfortunately may have had a bad first response, may have walked into the VA, sat down with a benefits counselor and been told, sorry, you're not a vet. It doesn't matter if they have a Purple Heart, doesn't matter if they served 2 or 3 tours, doesn't matter if they watch their buddy get their head blown off. They say, you're not a vet. Do you think they're going to come back to the VA and fill out a VA Form 1010-EZ? No. So they have to come to people like me, not a lawyer, to help them and counsel them and convince them that the VA is different now. It won't turn you down. And I'm not always right. I mean, the Harvard report was recent about their constituents, their veterans going into VA hospitals and being turned away, despite all of the recent training.
Well, thank you. And I think my time has expired, so I will now recognize Mr. Bost for 5 minutes.
Thank you, Madam Chair. Ms. Cinder, your testimony recommended the VA imposes its improve its guidance regarding the type of misconduct that would be considered willful and persistent. Can you elaborate on what you believe the changes should be, or where that line should be drawn?
Yeah, absolutely. That's a wonderful question. Thank you. So right now, what has happened is vets, according to the statute, are excluded from VA benefits if they discharged under conditions other than dishonorable. The VA has interpreted that to include misconduct that is willful and persistent, and misconduct that is involves moral turpitude and generally a felony. And this has permitted the VA, because there's not much guidance on what those words mean. In the VA Adjudicator's Manual, I screenshot the sections on that, give very minor instructions to the adjudicators. I don't envy the VA adjudicators trying to figure out what these terms mean. They don't have a ton of guidance, but there's not a lot there. The one thing I will say is that in practice and in a review of BVA cases that is reported in the underserved report that Sorts of Cautious put out, that if you look at those cases, the vast majority of eligibility cases are being denied based on the regulatory bars, and most of those are being denied based on this willful and persistent misconduct reg. And you'll see in there cases where folks who were AWOL for 1 week get barred from benefits because of that bar, or 30 days. And it just actually doesn't make sense. When you look over at the statute that Congress passed, it says to be barred from benefits, you have to have been AWOL for 100 or 180 or more days. And even then, they'll take a look at all the compelling circumstances that might mitigate why you were gone that long. And yet over at the regulatory bars, we have this willful and persistent bar that allows vets to get kicked out of the VA for 1 week of being AWOL. The outcome is just inconsistent, and I think it really, it is a great example of the VA's overstretching of their statutory authority here. We're also asking that the new regulations include clear guidance that mental health and military sexual trauma will be considered as mitigating factors in analyzing these claims. I understand that Ms. Carson talked about there being some training around that. The only mention of it in the VA's adjudicator manual is applies to the moral turpitude bar. But like I said, the vast majority of these cases are being denied on the willful and persistent ground. And it needs to be codified that those folks are going to have leniency in this review. Last but not least, I would also advocate that the VHA enrollment regs be modified to include clear guidance that anybody interfacing with somebody at the VA seeking to enroll, regardless of discharge, is encouraged to do so. I heard testimony this morning where they're talking about folks with other than honorable discharges, but there wasn't really a mention of those who go to the VHA who have a bad conduct or a dishonorable discharge. And are we training the VHA employees to treat those folks and offer them the enrollment form in the same way we are with the folks with other than honorable discharges?
Okay, my next question with a shorter period of time here. Ms. Montello, your testimony stated that the VA's COD regulations drastically depart from Congress's original intent. In your opinion, what's some of the common examples that VA denials on the basis of discharge status and that you believe follow a different standard than Congress's intent?
Thank you. That's a great question. I'll echo some of what Ms. Sedor said, that there are certain ways that the VA is denying veterans who have short periods of absence without leave. Importantly, that could never have led to a dishonorable discharge, that are nevertheless being excluded as willful and persistent misconduct. There are many other instances for clients of a single instance of drug use, or missing formation a few times. I have a client I represented who was kicked out less than honorably after she had missed a couple of mental health appointments because she just was not, her mental health condition after suffering MST was so bad that she couldn't even get out of bed. And so what we're seeing is that there is this really minor level of misconduct that VA is excluding on the basis of that is not what Congress had in mind as exclusion. And in fact, the Congress in 1944, when discussing this law, expressly intended to include, they talked about veterans who went AWOL, they talked about veterans who had minor instances of misconduct, and they talked about commanders who maybe, that depending on who you served under, you could have disparate treatment. And the fact is that VA regs currently over-exclude veterans and don't take into account mitigating or extenuating factors.
Thank you. And my time's expired, and I yield back.
Thank you, Mr. Boss. Mr. Cisneros, you're recognized for 5 minutes.
Thank you, Madam Chairwoman, and thank you to all our panelists for being here today. Mr. Goldsmith, I just want to ask you a fairly simple question. When's the last time a veteran came to you about their bad paper discharge? When's the last time they reached out to you for help?
My phone is buzzing in my pocket right now. I'm not going to look at it because I'm a witness at a hearing, but I'm willing to bet that there are people asking about what's going on. The last time was last week or maybe 2 weeks ago, where a young veteran here living in the district reached out to me because she too received a general discharge and therefore wasn't eligible for the GI Bill. Now, she is in school right now, and I spoke on the phone with her, my first contact with her, for over an hour, where she cried talking about the racism and sexism that she faced. As a young black woman in the Army, she was identified as black when people were talking about her. She speaks Spanish. People in her unit didn't know that she spoke Spanish, and people would refer to her in Spanish in front of her. She received a general discharge because she, was complaining about the racism that she was facing in the Air Force just recently. This isn't a long time ago. And now she's left without eligibility for the GI Bill. Someone who joined the military to be a nurse and to help us has been left out to dry.
Mr. Goldsmith, how often are you getting these calls? How many people would you say are calling you on a weekly basis?
After this hearing, I'm sure I'll get a spurt of them, probably a couple dozen. They come in all the time. I mean, I've gotten these calls from guys that I served with. One of my soldiers, a forward observer, came in after we got home from 2005. He was the kind of junior soldier who me and the other FOs were fighting over, because he was maybe about 5'5", but he was built like a pit bull, and he was the most motivated kid I ever met. While on patrol in 2007, during the troop surge, things were a little hairy then. He was at an outpost for, I think, something like a 24-hour period. The infantry platoon that he was assigned to wasn't used to having a forward observer with them. They left him sleeping out in sector in a combat zone during the troop surge. They didn't come back and find him. He walked back to base, or tried to walk back to base. Before the bolo even went out, after he had been missing for hours, he was found by another company from another battalion. A bolo hadn't even gone out, so when they saw someone dressed in an American military uniform walking in the road alone, they almost engaged him. Not a single officer or non-commissioned officer ever saw any sort of punishment for that. It became a joke. When he came home, he got a DUI, and then that's it. Bad paper, other than honorable discharge. No health care for you. Doesn't matter, that's the soldier that I wanted under me, that I fought for, was kicked out because he was a little shaken up after getting left in a combat zone. And, we talk about justice in the military and for the good of the order, but NCOs, high-ranking NCOs and officers who left my soldier in a combat zone by himself have never been brought to justice. But him, being a young guy, gets discarded like trash.
I'm running out of time here, so we'll try and. But Ms. Sater and Ms. Montalto, can you just really quickly give me your thoughts of what the experience is like for a veteran that reaches out to your team? What issues with their character of discharge discrimination?
Yeah, sure. I can speak to that. We run our intake every Tuesday morning. It's drop-in in our San Francisco office. We see between 5 and 20 veterans, and about half of them come to us with a less than honorable discharge. And they're there to get assistance on discharge upgrades, because that is the known process to vets on how to get anything from the VA. And it is a regular part of my job and my team's job to educate vets on this process, that there is an alternative to that might be quicker, that might, have a better outcome for them. They do not know about it when they come to see us.
All right, with that, I'm over my time, but thank you very much to all of you, and I yield back.
Well, thank you, Mr. Cisneros. And if Ms. Montalto would like to also answer Mr. Cisneros' question, we can allot a couple minutes to continue this part of the conversation.
Thank you. Very briefly, I will echo that my experience at the Veterans Legal Clinic is similar to Ms. Sedor's. We hear from hundreds of veterans every year, and a huge percentage of them are veterans with bad paper. And they come to us because they're seeking discharge upgrades, because that is the way that they think that they are going to finally get the mental health treatment and other supportive services that they need from VA. And while that is a thing that we can help them with, and we're happy to do so, the fact is that VA also has its independent obligation to decide eligibility. And we, like Ms. Sedor and Swords, do a lot of education around that and try to engage that process. And I just want to note that many of the veterans referred to us, and I appreciate this, are referred to us by VA. We have great relationships with our local VA in terms of helping. They recognize that veterans have legal issues and try to connect them to services. But often when they're referred to us, they're referred because VA thinks that they can't help. And there's just a huge amount of misinformation out there about eligibility. And most veterans, other than honorable discharges, are under the misimpression that they are categorically ineligible for VA benefits. And we need to make really significant efforts. And VA really needs to take the lead on that to counter that misimpression among veterans with bad paper and all of us who work with them.
Well, thank you for both answering the questions from the perspective of both of your organizations. I'm very grateful to those who participated today, both from the VA as well as those advocacy groups, legal service advocates, and then to Mr. Goldsmith for sharing your personal story with us as well. So I'm glad to hear from Ms. Carson that the VA is moving forward with revising its regulation. I know that process is still ongoing and has yet to be publicly released. But I think that this hearing will cause all of us to review that with even more scrutiny and determine if there are additional changes that need to be made. And I thank Ms. Sater and Ms. Montalto as well for their recommendations, and Mr. Goldsmith, of the things that we can do, some of them seemingly very simple, of forms dedicated specifically to this issue, as an example, and then other things such as increased outreach. I think it's become clear that there is a huge misconception amongst veterans who have this type of discharge that they're just not eligible, and we need to make sure that they can understand that there is a process by which that can be reevaluated through the VA, which again, as was stated earlier on, is completely separate from the process through the military service to change their official record through a correction of their service record. But through the VA for receiving the health care that they need, they can apply for VA benefits and they can be evaluated, and there are situations where they will still be eligible. So I hopefully, if anyone has viewed this part or all of this hearing today, they will take away the fact that the 1010 EZ form is what we use now, but I think that you are correct, that something more deliberate for that certain purpose might help communicate the message to the people who could be eligible for COD review. I'm trying to see if there's any other required information. But just close out by thanking everybody again for appearing before the committee today. The committee's goals is always to improve the process for veterans, to work with the VA, as this is an oversight hearing, to take the information that we can receive to help improve the processes and our part on the legislative side, as well as the resources side. Like we discussed with Ms. Carson, I'll look forward to your answer about any additional resources that could be required to help the VA accomplish this mission and help you better serve our veteran community. So I will conclude there and recognize Mr. Boss for 5 minutes for closing remarks.
I would just like to say thank you all for, this is not an issue that we're just going to let go away. We will pursue it and make sure the VA moves forward at the best and the intent of the law is carried out, and if the law needs to be changed and adjusted, we should be able to work with our committee staff and groups like yours to try to figure out what it is needs to be done.
Well, thank you, Mr. Bost, and to the other members who joined us today. And I would like again thank the staff of the committee for all of your work to put this hearing together, and especially under the specific requirements during COVID and a remote or a partially remote hearing. So thank you again for that hard work to make this happen. I would like to advise all members that you have 5 legislative days to revise and extend remarks and include any extraneous material. And this hearing is adjourned.